Hello, this is Professor James Strickler, and this is a course in American government. This lesson is from Unit 12, about the Georgia Constitution. It's Lesson 13, about Georgia's judicial branch. In this lesson, you'll learn about the various types of courts in the state of Georgia. You'll learn about the organization of those courts. You'll learn about each court's responsibilities. You'll learn about the qualifications to be a judge on one of those courts, and you'll learn about district attorneys. This lesson is one of a series of lessons where we're walking our way through the Georgia Constitution, article by article. This lesson will be drawn from Article 6, about the judicial branch. Now, you've previously learned that the judicial branch in the state of Georgia has some significant constitutional power granted to them in the state constitution, where it says that they have a responsibility to declare void any law that they find violates either the Constitution of the state of Georgia or the Constitution of the United States of America. This is the power of judicial review. This is the power that a judicial branch uses to check the other branches of government. Unlike the United States judicial system, which is not given this power anywhere in the Constitution, but just simply did it and got away with it, the Georgia judicial system is specifically granted this power. This gives them important power within the system of government here. But who has that power? What types of courts exist in the state of Georgia for exercising it? The Georgia Constitution, in Article 6, says that the judicial power of the state will be vested exclusively in the following courts. And then it goes on to list a bunch of them. First, let's note that it says that there'll be a Supreme Court for the state of Georgia, just like there's a Supreme Court of the United States, but don't mess up the two. The Supreme Court of the United States is presiding over the enforcement of the United States Constitution and United States laws, while the Supreme Court of the state of Georgia is overseeing whether or not people are following the state constitution and state laws. Below that Supreme Court, there is a Court of Appeals that hears appeals. Now, this is a concept we've talked previously about in this course, and we'll bring up again later in this lesson. There are what are called superior courts. There are state courts. There are juvenile courts. There are probate courts. There are magistrate courts. And in many cities in Georgia, there are also municipal courts. Now, this is a potentially very complicated system for the courts in the state of Georgia. You may recall that when we talked about the courts in the national system, there were just three types of courts. There was the Supreme Court of the United States. There's a whole system of appeals courts below them. And then there were the district courts where trials were conducted. Well, Georgia here, as you read through this, it has 8 different kinds of courts, not 3. Now, does that really make the court system here in the state of Georgia more complicated? Not as much as you might think. So now to understand that, let's look at how the courts in the state of Georgia are actually organized. To help us understand that organization, let's remind ourselves of a concept we learned earlier in this course, the concept of jurisdiction. This means the authority of a court to hear a particular case. If they have jurisdiction, they can hear that case. If they can't, then they don't. Remember that we talked about 2 different kinds of jurisdiction, represented by this green and yellow rectangles. The green rectangle is representing original jurisdiction. This is the level of trial courts. These are the courts to first hear cases. That's why it's called courts of original jurisdiction. We also, previously in this course, when we talked about original jurisdiction, learned that original jurisdiction is worried about questions of fact. Did you actually pull the trigger on the gun that caused the death of that person? That kind of thing. That is what courts of original jurisdiction, as they have trials, usually in front of juries, decide. Later on, when I diagram out the courts in Georgia, those that are courts of original jurisdiction, I will color green. The other kind of jurisdiction is appellate jurisdiction. This is where courts hear cases on appeal. Something has happened in the original court that a party to that case didn't like, and now they've appealed up to a higher court. But when they appeal up, you may remember they're not appealing questions of fact. They're not going to dispute whether or not those were actually their fingerprints on the gun. Instead, they're going to dispute whether or not the law was correctly followed in the lower court. For example, they might say, well, you know, I'm not going to dispute whether that was my gun or not. I'm going to dispute whether they could show it to the jury because they found the gun through an unreasonable search of my house without a search warrant. That's the kind of issue that would be raised in a court of appeals. Now, Georgia, of course, has both courts of original jurisdiction and appellate courts. So let's begin with the courts of original jurisdiction and create a diagram of what the courts look like here in Georgia. Now, remind you that those courts of original jurisdiction, which we saw listed on the first slide, are municipal courts. Those are courts that are within a particular city, dealing with city issues. We'll talk more about that later. Superior courts, magistrate courts, probate courts, state courts, and juvenile courts, which are all courts of the state of Georgia. These 6 kind of courts are all trial courts. Now, why would you need 6 different kinds of trial courts? The most obvious explanation, which is true, is that they deal with different kinds of trials, different subject matter. And we'll talk more about that in a moment. But let's get them on a diagram. So here are the 6 trial courts in the state of Georgia. Now, one of them, the Superior Court, I have with a slightly larger box than the others. And this is to represent that it is special, different than the others. The reason it is special is because it has both original jurisdiction and appellate jurisdiction. That's why it has both green and yellow in its box now. Well, appellate jurisdiction, where does that come in? In an unusual setup, the state of Georgia has a system where the 3 lowest of the trial courts, in other words, when I say lowest, dealing with the least serious matters, can have their cases appealed to the local superior court. Now, when these cases are appealed, it's not a matter of, like we described appellate courts doing, going through and trying to determine the questions of law where the law is correctly followed. Instead, appeal up to the superior court from one of these courts is what's called legally a de novo appeal. In other words, the superior court will take the whole case over as an original matter. They will just simply redo the trial, so to speak. Start over from scratch if they're going to take the appeal. So they have both that function and their own normal trial function, which in a moment I'll tell you about what kind of cases come to them originally. Now, the next layer above these 6 trial courts are the Georgia appeals courts, which will have, obviously, appellate function. They will hear cases on appeal to consider whether or not the law was followed. And in one way or another, all 6 of these lower trial courts can appeal up to the Court of Appeals. There's only one Court of Appeals in the state of Georgia, not a whole system of them like in the national court system. So wherever you start in this system of trial courts, you could eventually have your case heard by the Court of Appeals. Then above the Court of Appeals, we're going to have a state Supreme Court, which will have jurisdiction over all questions of law within the state. So let's add that to our diagram. So this then shows you how all 8 of the courts in the state of Georgia relate to each other. Now, what kind of responsibilities do each of these 8 different kinds of courts have? This table is going to help us to figure that out. Now notice in the boxes on the left we have the 8 different kinds of courts listed. They're listed from top to bottom, from the court with the most serious authority down to that has the least authority, in other words, or at least authority over the least serious matters. And then the boxes on the right-hand side, we're going to put in there the responsibilities they have. In other words, what kind of cases are they actually hearing? So let's start at the bottom with the court that has the least serious issues to deal with. Those are municipal courts, which deal with ordinance violations. Ordinance violations are those ticky-tacky little laws that a city or a county might make. Things like your grass can only grow so high in your front yard, or your dog can't poop on the sidewalk, that kind of thing. And people get in trouble for those. They get a fine. They don't want to pay the fine. They go to court and challenge it. That sort of thing happens in municipal court. The next most serious kind of court is the magistrate court. This deals with civil lawsuits, where somebody is asking somebody else for money, but in only values below $15,000. Now, that $15,000 may sound like a lot, particularly to somebody who's a college student, but in the big scheme of things, it's not a lot of money to be going to court over. The next level of court are the probate courts. These deal with wills and estates. This is where somebody has died and there's a dispute over who gets their stuff, basically. Considered a little more serious than just a civil lawsuit, potentially involve more money than a civil lawsuit. The next level up are the juvenile courts, dealing with what are called juvenile delinquents. Now, this is an old phrase you don't hear said often anymore, but basically what we're talking about is people who are under the age of adulthood who are troublemakers of some way, or at least accused of being troublemakers of some way. They go to juvenile court to have their issues resolved. The next level up are the state courts, where misdemeanors and civil lawsuits are taken care of. Now, when I say civil, I mean that there's going to be civil lawsuits above the amount that are in the magistrate court. These are for bigger civil lawsuits. Now, what are misdemeanors? Misdemeanors are crimes. This is criminal law. But they are minor crimes, things that you would end up, even if convicted, get less than a year in jail for. Next level are superior courts. These deal with the most serious criminal acts, felonies, where you can spend anywhere from above a year in prison up to having your life taken away through execution. They also deal with another very serious issue, divorces, which can be very nasty. And the really big civil lawsuits can go there also. There are also courts of appeals. These appeal courts obviously deal with appeals, where you don't like what happened to you in one of these lower courts and you appeal up to the Court of Appeals. And then finally, if you don't like what you got from the Court of Appeals, you can appeal up to the state Supreme Court. Matter of fact, the state Supreme Court has exclusive appellate jurisdiction. In other words, they get these appellate cases appealed to them sort of automatically in two cases described in the Georgia Constitution. Those are cases where an issue of the constitutionality of a law has come up. You get to go straight to the state Supreme Court with that appeal. And the other are any appeals about election results. Those go straight to the Georgia Supreme Court also. Okay, now that we know the jobs that the courts of the state of Georgia fulfill, let's talk about how people are chosen to be judges on these courts. This time, let's start at the top with the most serious judicial positions, those on the state Supreme Court and the state Appeals Court. The people who serve there are elected by the people for 6-year terms. If we then go below them, we've got 4 other judgeships where people are elected judges are elected by the people for 4-year terms. Now we've got 2 courts left here that don't fit. Well, what's the case with them? First of all, the juvenile courts, rather than being elected, the judges there are appointed by fellow judges. Now, there's a good reason for this. Juvenile courts dealing with underage offenders are particularly delicate situations. You might need a particular kind of judge there. And the feeling is that fellow judges would be better able to discern whether somebody's properly suited for that job than the voters would be. So those are appointed by other judges. The last one, the municipal courts, is a local choice. The the local city government decides how they will go about choosing those judges. In some cases, they might be appointed by the mayor. In other cases, they might be elected by the voters. Okay, now that we know how people get these jobs, what are their qualifications to get them? Well, again, we'll use a table to make it easier for us to follow what's going on. Let's start with the positions at the top. Again, the most responsible, serious judgeships in the state. To get any of those jobs, to be elected to them, you have to have been practicing law in the state of Georgia for at least 7 years. Juvenile courts, you have to have been practicing law for at least 5 years. Probate and magistrate courts, you only need to be a high school graduate to serve in those positions. I'll come back to that in just a moment. And last one, the municipal courts, is a local choice, what they want to put the qualifications at. That city that's setting up that court system with permission from the General Assembly decides what sort of qualifications they want their judges to have. Now, you may look at those two positions, probate and magistrate judge, and say, wait a minute, how can they only have people who've graduated from high school serve in those positions? Well, first of all, that's not going to happen most of the time. But even when it does, it's probably going to be people that have some sort of other experience with courts before they try to get elected to these positions. Maybe they've been a court clerk, or maybe they've served as a local sheriff or something like that. But even if it were somebody straight out of high school applying for these positions, or I should say running for these positions, getting elected, there's a way to provide them with the training that they need. That is something called the National Judicial College in Reno, Nevada. See, this idea of people only needing a high school degree to get elected to be a judge is not an uncommon thing in the United States of America. That may be surprising to you, but there are lots of other states that have similar situations. So they get people elected to be judges who don't really know how to be judges. Well, what happens then is they run off, hop in a plane, fly to Reno, Nevada, and take a crash course in how to be a judge. Then fly back to Georgia and serve in that position. So no, you're not getting untrained judges in there, even if they are elected without any background as a judge. Now, why might they have had this set up? Well, there was probably at least a time period in the state where you didn't think that there was really enough people to go around to serve in these positions that had legal training. In some local little town where they had one of these judgeships, maybe they just wanted the old wise guy in the town that everybody trusted to serve in this position, whether he had a law degree or not. So just having a high school degree would be good enough for him to sit there and deal out justice. At least that's what the traditional idea was. Okay, the last thing from Article 7 that we want to address in this lesson is Georgia's district attorneys. District attorneys are people who serve in the state government to represent the state in criminal cases. In other words, they're the prosecutors that accuse you of having broken a law and go to court and try to prove that. These people are elected also in the state of Georgia. They are not appointed. So they are another political office. All right, that completes this lesson where we talked about the judicial system under Article 7 of the Georgia Constitution. Let's review now what you learned. Which of the following is not a Georgia trial court? Superior court, appeals court, probate court, or state court? Now remember, the trial courts are the courts of original jurisdiction at the bottom of that diagram we had. Well, what's above them? Appeals court. If you're not at trial as a court, then you're going to be a court where things are appealed to you. So the name right there tells you that it's an appeals court. What kind of court deals with felonies? Juvenile court, magistrate court, municipal court, or superior court? Superior court are the only trial court in the state of Georgia that deals with felonies. What is the minimum education needed to be a judge in the state of Georgia? Is it a Juris Doctorate? That's another name for a law degree. Is it a master's degree? Is it being a high school graduate? Or is it having a bachelor's degree? The minimum qualification to serve as a judge in the state of Georgia is having being a high school graduate. And that's just for those two positions of magistrate judge and probate judge. What is the job of a district attorney? Is it to prosecute crimes? Is it to advise the mayor? Is it to be a lawyer for schools in the state? Or is it to bring lawsuits against the government? If you're a district attorney, your job is to prosecute crimes. All right, that completes this lesson. The next lesson will also be from Unit 12. It'll be Lesson 14 about Georgia taxation.